160 pages of debate. Guzari Nanda says that you cannot change 370 till you follow 370. So all that, what is happening is we're expanding all this, which is not part of.
I may assure my learned friend.
At least you should point the facts out.
Lord, there is no intention, Manoj. Everyone, we were led by eminent people. Everyone contributed. There is no Lord, undermining the contribution of anyone. The only purpose was voting may differ. This was the view consistently explained, and Lord, my only purpose of reading was this is how the country treated it as temporary. That's all. My learned friend may take any other meaning out of it. Everyone contributed, but even 370 must have come with good intention of integrating the nation. The purpose of reading the debate was, and is, my lord, I'm not reading it now, that it was conceived from the beginning as a temporary provision. That's all, my lord. Not to undermine anyone's contribution. Lord, I pointed out CO, and now, my lord, I requested your lordships to allow me to place only 4 paragraphs of Damnu. Your lordship knows, my lord. Case law compilation, my lord, volume 1, 36 at 44. I read only the relevant part. Volume 1 compilation, page 36 at 44. But before rising for lunch, when your lordship rose for lunch, I read the constitution order, which was under challenge. Makbul Damno. Para 19, Manoj. But at page 44, your lordships would find Article 367 as modified is quoted. Then para 18 may not be relevant, 19. Your lordship gets that. May I read with the Lord's permission? On November 17, 1956, Jammu and Kashmir Constitution was adopted. Some sections came into force on that date, and remaining sections came into force on January 26, 1957. But nothing turns on that. At the last 2 lines of that para, my lord, order of 1965, under this order, for clause B of clause 4 of Article 367, the following clauses were inserted. So then, Sadr Riyasat becomes governor of Jammu and Kashmir. Correct, Manoj? Now please come to 21. According to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at that time. But it says at that time because 65 was the CO, 65 or 66, but the matter was heard, my lord, somewhere in 70s, therefore. Nothing turns on that. According to Mr. Garg, this is the kingpin of the whole relationship between the Union of India and the state of Jammu and Kashmir. According to him, neither the Jammu and Kashmir Assembly nor the President were competent to impair the functioning of Sadr Riyasat. And insofar as Constitution of Jammu and Kashmir Order of 1965 replaced the Sadr Riyasat by the Governor, it is ultra vires. According to him, either there has to be an amendment to of the Constitution of India under Article 368 and Article 370 sub-Article 3, or a fresh Constituent Assembly has to be convened to amend the explanation. Please mark this. This was, my lord, the contention being considered by your lordships. 22. It seems to us that the essential feature of Article 370 subclauses B and D is the necessity of concurrence of the state government or consultation of the state government. What the state government is at a particular time has to be determined in the context of Constitution of Jammu and Kashmir. Please mark this. Lord, I very respectfully, heavily rely on this finding.
Yes.
The explanation did no more than recognize the constitutional position as it existed on that date, and the explanation as substituted from November 17, 1952 also did no more than recognize the constitutional position in the state. So earlier CO is also not taken into consideration. That whoever was in office was recognized by way of an explanation added to Article 367. Then number 24. The learned counsel relying upon Sampat Prakash contended that the only way of modifying Article 370 is specified in Article 370 sub-Article 3 itself. He said that this was expressly laid down by this court in the decision just referred to. We are not concerned with the question whether Article 370 sub-Article 3 can now be utilized to amend the provisions of Article 371 and 2, and therefore we do not express any opinion on that point. We are now not concerned with the amendment of Article 370 sub-Article 1. We are concerned with the situation where the explanation ceased to operate because there was no Sadr Riyasat. It had ceased to operate because there is no longer any Sadr Riyasat of Jammu and Kashmir. If the definition contained in the explanation cannot apply to the words government of the state, then the meaning given in Article 367(4) as amended will have to be given to it. So if an authority contemplated under Article 370 ceases to exist, it can be replaced by the successor or the closest possible successor under 367. Yes. If this meaning is given, it is quite clear that the governor is competent to give the concurrence stipulated in Article 370 and perform other functions laid down by Jammu and Kashmir Constitution. Now your lordships may kindly come to the last para, 26. It is true that governor is not elected as was the Sadri Riyasat, but the mode of appointment would not make him any the less a successor to Sadri Riyasat. Both are heads of the state. But I am not reading this in the context of Constituent Assembly being read in the same mechanism of Article 367 to be the legislature. Now coming back, my lord, to my submissions, my lord. Lord, written submissions, volume 3, combined written submissions, volume 3, my lords. I'm sorry, my lord, if your lordships are at the judgment, my lord, can I, only one my lord, argument, my lord, I left, my lord. Para 28, my lord, I'm sorry. At page 47. I missed that, my lord, I should have read that. This was also an argument, my lord. A similar argument is made before your lordships by the petitioners, my lord. Therefore, I am relying upon para 28 in Damnu judgment, my lord, at page 47. Para 28, your lordship gets, my lord justice. Yes. Mr. Garg drew our attention to clauses AA and B of Article 367(4 as substituted by CO 74 of 66. We have already set them out above. He said that this was an amendment of Article 370 sub-Article 1 by the back door and the President could not exercise these powers under Article 371 when he had not purported to exercise these powers under Article 370 sub-Article 3. But, as we have already said, the explanation had become otiose and references to Sadr-e Riyasat in other parts of the Constitution had also become otiose. There were two alternatives. First, either to leave the court to interpret the word government of the state and give it its legal meaning, or secondly, to give the legal meaning in a definition clause, that is Article 367. What has been done is that by adding clause AA and B in the definition is supplied, which the court would have in any event given. Therefore, we do not agree that there has been any amendment of Article 370 sub-Article 1 by the back door. Just for completion, 32 on that page. It is also not necessary to dwell on the third point, namely violation of Article 21 and 22 of the Constitution, because it is clear that they are excluded by Article 35C of the Constitution. Now, my lord, coming back to my written submissions. Page 83. Again, my lord, as I had done, I'll skip what is not, my lord, relevant right now and is added only for completion. Page 83. My lord Justice Gawai, my lord, my summary, my respondents' written submissions, volume 3. Page 83. Your Lordship guessed it. 17-2-1969, Article 248 was applied in a substituted form, giving exclusive power to the Parliament to make laws with respect to the prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India, or bring about secession of a part of the territory of India, or secession of a part of territory, etc., etc. Lord, this is where the residuary power in a wide sphere dealing with sovereignty was given. Then your Lordships may, my Lord, kindly come to page 86, my Lord. 85 bottom. I am skipping 2 pages now. 85 bottom. 6/5/1972, your Lordship has taken. It further expands the residuary power of the Parliament. CO 93. CO 93, the scope of Article 248 was increased, whereby the exclusive power was vested to the Parliament to make laws with regard to the prevention of activities of disrupting the sovereignty and territorial integrity, etc., to also include taxes on foreign travel, inland air travel, postal articles, etc. Then your Lordships may, my Lord, come to page 87. Lord, 28th of August 76, 42nd Amendment of the Indian Constitution come into being. Lord, what was not applied was the word socialist and secular. I have already pointed out. The word integrity was not applied and fundamental duties were not applied. Then March to July 1977, the President rule is applied, is imposed. Lord, I have given the note. Lord, please note, Lord, as a matter of fact, till 2023, Governor's rule under Section 92 of the Jammu and Kashmir Constitution have been imposed 8 times and precedence rule. I'm sorry, my lord, your lordships are at page 87 at the foot of the page. Till 23, governor's rule under 92 of Jammu and Kashmir Act 8 times and precedence rule under Article 356 3 times. My lord, under 92 there is a stipulation that it cannot exceed 6 months. Therefore, then my lord, next date, 9/5/78, 44th amendment of the Indian Constitution was brought in. The note, the non-application of the said amendment resulted in non-application of clause 4 of Article 22, which provides for major protections against preventive detention, which were not applied. This is what they lost, and this is what they started getting from 2019.
Article 22 has not been notified yet, right? So for the rest of the country, it has also not been notified as yet.
No, but it is, Malad.
22.4 is not notified.
4 to 7 is not yet.
I'll check up. I'll check up.
But TK Roy's case.
But you can't issue a mandamus to notify a constitutional amendment.
In Article 359 related to suspension of enforcement of rights conferred by Part 3 during emergencies, the words except Article 20 and 21 inserted by 44th Amendment not applied. Hence, an absurd situation arises where in Jammu and Kashmir, even Article 20 and 21 can be suspended during emergencies, while in rest of the country it cannot be done. That's all, Malad. Emergency provision is a provision of 44th Amendment. Malad. There is, and the net may not feel angry about it. Malad. That's the provision which is not applied. That's the only purpose of pointing out. Then, Malad, next, 4th June 85. It modified Article 248 as it applied to the state by empowering the Parliament to make law for prevention of terrorist activities. Now, please see the note only, that's relevant. This indicates the government of India was taking steps to maintain law and order in Jammu and Kashmir. Notably, the modification to the union list included the term disrupting sovereignty and integrity of India. Then, some provisions with regard to scheduled tribe and in the state, where, my lord, but that were in a truncated way, not for election purposes, etc. Nothing turns on that, my lord. Then 30th of July 86, my lord, page 89. The same order,
June
this is
1985, and June 1985 entry 97 was also applied, though confined to this area.
Yes. Lord, that was made applicable, it was expanded, Lord, it was applied in 69, 1969. I'll just, Lord, if your lordship comes to page 83, it is 17th February 1969, where entry 97, your lordship would find the first para, last, second line. Does your lordship get, my lord, the Chief Justice gets?
No,
Lord, page 83, date is 17th February 69,
yes,
085, the first para, last line, my lord. Further, entry 97 of the union list was applied in a modified form,
right,
dealing with the above subject.
Right.
Then, my lords.
Now we go back to your...
Yes, yes, my lord. Page 89, my lords. The said order was order issued during governor's rule. My lord, this is important. And the notes would be more important. Several COs are issued during governor's rules also. That has been a consistent practice under constitutional convention. The said order issued during governor's rule modified Article 249 in its application to the state to state that the Rajya Sabha, by passing a resolution with over two-third majority, could empower Parliament to make laws on any matter specified in the resolution, bring a matter which is not enumerated in the union list or concurrent list. Before I go further, I must deal with one submission.
So writ petition civil 1099 of 2019 did not challenge these three things.
My lord, writ petition is by...
Did not challenge the governor's rule, president's rule, or before that?
No, my lord, I must point out, the governor's rule is challenged, but after 14 months, when...
After, in
5th and
1099.
6th of August 2019, when that was must be being drafted, it must have been advised that you have to challenge the main imposition. That appears to be the case.
So the governor's rule was challenged.
Challenged after 14 months.
Then obviously the president's rule would have been also challenged.
Yes.
Bound to be.
Yes,
and,
bound to be.
And dissolution of the legislative assembly is also challenged.
Is not challenged.
Is not challenged.
Is not challenged. Still not challenged. In any of the petitions till date.
Till now, none of the petitions is challenged.
Yes. None of them.
And that's in terms of section 53(2).
Yes. And my lord, the petition argued by Mr. Sibal, which was which is number 10 loan Abdul.
That was 10.
Muhammad Abdul loan, my lord, which was by NC, my lord, National Conference. Not even President's rule or Governor's rule under challenge. Well, I have a list. I have the list, my lord. I'll just show that list, my lord, to your lordships. Very sad list.
True of fact, what is the governor's rule was challenged through a PIL filed in this court, dismissed. There was a PIL filed in this court, challenges governor's rule, was dismissed by Justice Gogoi. And I'd be very happy if this court were to say that because all this was not challenged, the entire process that is adopted is constitutional.
When did I argue that? My lord, why
I'm very happy if this court were to say that.
My lord, where did my learned friend, my lord, why is he presuming what I'm going to argue?
Since you are talking about it.
No, I am talking about it because half an hour of a political kind of an argument was made. How can you dissolve the assembly like this? What are the powers of the governor, etc.?
The bench of this judge of this court has said you can't do it.
Correct, but you can't argue it without the challenge.
I have never made a political argument in this court, and your lordship knows about it. Not a single political.
But if there is no challenge and if you raise a plea that there was the governor should never have dissolved, it becomes a political argument. It's not an argument based to suppress.
But taking your point that Mr. Sibal, the writ petition, there was no challenge to President's rule, governor's rules or the dissolution.
Yes, and dissolution not in challenge in any of the petitions.
That we got.
So, my lord, that question your lordships need not go into. That's the my lord, respectful submission. And my learned friend is right. Please, if you don't mind.
Paper book 501.7, in fact, their counter affidavit has a listing of all the prayers of all the
I
petitions.
was going to say that, please allow me. I have prepared a list and placed it, my lord. This is the submission in support of my lord, plea that your lordship need not go. Because a substantial time was consumed on this argument. Therefore, my lord, I am laboring this point that it was not necessary. My lord, please come to my lord, volume 501.7, paper book 2993. My lord, the prayers are quoted. Which document file are you saying? Which document?
Paper book.
The main paper book, my lords. Thank you.
1.7.
7.
Page
page 2993. Why would I not point out something which is in my favor and I have placed with my reply?
Folder 2993. Is various item number.
लाइट का जलाई गर्मी में वाह
Your Lordships have seen the chart. These are the only prayers before your Lordship. And that too after 5th and 6th of August 2019, after 14 months. And I have, my lord, also narrated a chart showing the pleadings also.
But we have petitions where everything is challenged except the dissolution of the Legislative Assembly.
Correct. No, my lord, there are petitions.
There are
actually.
petitions challenging the imposition of governor's rule, the imposition of president's rule, and but according to you, no challenge to the dissolution of the Legislative Assembly.
Correct, my lords. But one factual clarification. In some of the petitions, even that the governor's rule is not under challenge. For
There are some petitions where there is.
Yeah, yes,
but
but
we'll
some
have to deal with
petitions
it anyway. Once it is raised,
to
even in
have a challenge to governor's rule.
But governor's rule was challenged in most of these petitions post the president's rule.
All the petitions post the decision. That is why
What Mr. Sibal said, there was an earlier petition filed which was discussed.
Yes, my lord, that's what, my lord, I have pointed out, my lord, in my summary of submissions, my lord. Please see, my lord. That is, my lord, at page.
If there were no actions on 5th and 6th, we won't be here. We wouldn't have challenged anything. We are challenging the actions under those provisions.
No, let Mr. Sibal.
Just saying.
No, I am also, whenever interrupt, I am just saying, but don't do that. That's why the rejoinder stage is always there. I understand your discomfort, but what can you do? What can I do?
I understand you.
PIL. Not PIL, it was not a PIL. I'm sorry, it was not a PIL. My learned friend, my lord, possibly not correctly briefed. It was PDF 250. Take my lord, PDF 250. I have, in my written submissions, my lord, I have done this. One MLA challenge, it was not a PIL. Please see, my lord, the order of this honorable court. And kindly have a look at, my lord, at PDF 250.
same paper book.
Yes, my lord. No, I'm sorry, volume paper. No, I'm sorry, written submissions paper.
You are taking us back to volume 3?
No, my lord, the same volume 3 of written submissions.
That's what I'm saying.
Yes, there, PDF page 250. This Gagan Bhagat was not a PIL petitioner, he was an MLA.
BJP.
We argue, anyway, my lord, we learn from my lord, senior, my lord, I will not say anything more than that.
Yes, I know.
I am only arguing a matter, my lord, I have no political
Yes, let it finish.
exchange. My lord, I have nothing, this is a constitutional point for me. Your lordship gets that order, my lords?
This was a petition challenging President's rule.
Yes. No, I have this.
Governor's rule.
Dissolution, I'm sorry, dissolution.
This was against for challenging dissolution or the governor's rule?
Dissolution. Dissolution.
Therefore, they have not included that prayer in any of these petitions because that is attained finality.
But that's what they came to know when I say in my written submissions. They were not aware of it. They have not mentioned that we have not challenged because it is affirmed by the Supreme Court. I'm sorry, madam. The Lordship said that we have heard, we have seen the record, and we dismiss the petition. Therefore, I am not going into the details. Otherwise, my lord, I can show details also. But there are reasons, my lord, why it is not challenged. My lord, when you don't have a case on the floor, you don't challenge it. That's as simple as that. But let's not go into it. Why they have not challenged it? It's definitely not because this petition was filed and dismissed. Because none of the petitioners say that this petition was filed, heard by this court and dismissed, and therefore we are not challenging it. They came to know possibly only when I pointed out in my written submissions. So far it was not on record. Now, Lord, page 95, 1912-2018. Lord, proclamation under Article 356.
Yeah.
Lord, here, my lord, I must answer one question. Lord, suspension of proviso to Article 3, my lord, that was an argument. There are two arguments. The argument was advanced with a nuance that this was a device to bring certain legislative enactments or certain parliamentary actions by suspending the provisions of the article, the proviso to Article 3, namely the reorganization. Like that was the allegation. Correct, my lord? Your lordship recollects that. As a matter of fact, right from the inception of this country, whenever President's rule is imposed, proviso to Article 3 is stayed. We have studied each and every proclamation issued by the President under Article 356 with regard to each and every state, not Jammu and Kashmir. Proviso to Article 356 is suspended in every case, and please have a look at, my lord, the chart which I have, my lord, placed at page 227 of this very file, my lord, of this very volume. As if we did something surreptitiously because some sinister plan was in the mind. This happens right from the inception. The first President rule was in Kerala in 1957. Since then, my lord, we have studied, and my lord, we have the learned AG also has the volume, my lord, if your lordship would like to see that. But I have said so. So please come to page 227 of this very volume, my lord. Two 26 minutes. Now please see, Andhra, Arunachal, Assam, Bihar, Goa, everywhere, my lord, suspended. The lordship would come to page 9, clause 9, erstwhile state of Jammu and Kashmir. Twice, 86 and 90. On both the occasions, the provision to section Article 3 was suspended. There is a reason, my lord, why this format is used. It's not to do something surreptitiously. Lord, in S.R. Bomai, the law laid down, and I will come to that, the law laid down is that the legislature cannot function without Council of Ministers. When that is the position here, additionally, the legislature was dissolved, but otherwise also, whichever provision of the Constitution mentions something to be done by the legislature, that provision is suspended. That's the format to be used, being used from the beginning. 1977 was the first use of 356, 59. Mr. Namboodiripat's government was removed and the President's rule was imposed. That was the first and perhaps the most controversial imposition of President's rule. There also suspension of 3 proviso was there. We have the notification if your lordships would like to see that. The proviso is added. The exercise which was undertaken so far under 367 was again undertaken for the purpose of Jammu and Kashmir. For Article 370, the word Constituent Assembly was replaced by the word Legislative Assembly. Same thing, because Constituent Assembly ceased to exist, it became Legislative Assembly now. And the rest, I have already explained. Tomorrow. There was one request, my lord, if it's a more of a convenience request. My lord, if your lordships were pleased to sit on Monday, Lord, if your lordships can consider sitting even on Friday, maybe, my lord, we might be able to, my lord, finish.
Your whole side can wrap up then.
Yes.
So that then
Because there is one holiday, that's, my lord, the request, my lord, if it suits your lordships and the other side, my lord.
By 1 o'clock on Friday, we'll give you up to 1 o'clock on Friday.
No, I will finish tomorrow.
No. You means your side. So that you can all,
I can't
you are
say
saying
about
until 4 o'clock. You are only saying if you can all finish by lunch on Friday, then there's no difficulty. We can sit on Friday, but all of you can try and finish upon. No, you have to do it. I know you, but now it's going to be repetition because by next Tuesday we want to give them 2 days in rejoinder. Mr. Giri, otherwise this will go sometime to September. The bench may not be available for 10 days, 12 days. We don't want to take a
Keeping
break.
that in mind, my lord, I am requesting for Friday.
What was session on Monday, my dear?
No. We will not. We'll wrap up on Friday.
Not Thursday.
Lord, in fact, we have bifurcated the subjects. There may not be much of a duplication, but
Thursday is a holiday, right? Wednesday is a holiday. So we'll decide tomorrow, but you can all meet in the evening so that your side is completed on Friday. We don't mind stretching it a little more on Friday beyond 1 o'clock, so that we don't come back after lunch. We'll give you a little more time.
Finish it by Friday.
do this on Friday, we can start at 10. We give you 3 hours on a trot and wrap up on at 1 o'clock for your side. So at least we're giving you a little more time on Friday.
We'll discuss and come back tomorrow.
Give us a solution. I know, but everybody now has to, because we've heard the other side, so we've seen the entire material. Now we are hearing submissions really, because we don't have to read. Now even the judgments have been read out to us. So
As short as possible, but some little.
that's all that we are requesting. We are sure that you can achieve it. Mr. Giri, we are.
Then not see. Lordship said same. Then it went on the other side also. Somebody was given half an hour to 2 hours. We'll not do that. Some perspectives will have to be placed. Lordship's may most graciously take note of the fact that.
All right, but please do meet this evening in a way that, on Friday between 10 and 1, we will hear you on a trot for 3 hours and we'll conclude this side on Friday. Then we'll give them Monday and Tuesday to wrap up the rejoinders.
Your Lordships then give us time for the whole of Friday. We'll do.
There's some difficulty about the whole of Friday. That's why we are saying.
Very.
Obliged to know.